I will do most of that with the directions, but we'll still explore maybe we could come back. Also noting that my client has been in custody for quite a lot of time.
I'm just saying that I've considered the application by the defense to have the application for bail the soonest. It is, however, prudent to have the cases the prosecution is claiming that it intends to consolidate to be consolidated and the bail considered at once. Now, the reason for this will be to save the court the agonizing, energy-consuming effort of writing a multiplicity of rulings on the same matter. I'm fully aware, and this is straight law, that once heard together, each application by each accused person will be determined, giving consideration to the unique facts and circumstances affecting each of their cases, and the results may be different for each accused. So in that case, I'm ordering that this matter be argued together with the rest which are connected to it.
Much obliged.
Before you close your file.
I'm not closing because you have not finished. Now, I wanted to ask a question. I've seen 3 files connected to this matter. How many do you have in the offing? Because you seem to unleash like antibiotics.
That may appear to be so, but it's not entirely correct. The two accused persons yesterday and today had already appeared before court and had gotten appointments for yesterday and today respectively. That is why their dates in court for plea are different. For now, Your Honor, those are the people.
How many cases do you have, Mr. Wandari?
That's the next point I'm making. For now, those are the accused persons we have before court. Investigations are still going on to look for the other suspects. I cannot...
Make it simple. How many people do you have so far?
These are the three people we have, and that's what I've said, my lady. But investigations are going on. Of course, there are three other suspects out there, and the police are following them. So for now, we have 3 cases, and we'll be applying to have them consolidated on the 8th.
Now, the other question I want to ask, where are your witness statements, evidence, documents that you wish to rely on?
We said, my lady, we will serve all the parties by Wednesday next week. We shall be ready with all the documents.
Yes, the next week is which date, so that I write it down.
Wednesday will be 3rd. 3rd of October.
Anything else you wish to say?
I wish to add this. Your Honor, my lady, as I've said, the investigations are ongoing. There are suspects out there. When we serve these documents, statements that we intend to rely on, that will not be all. However, we will serve the defense as and when the investigations are complete, with a complete record. We'll, of course, give them in good time for them to be able to prepare their defenses.
They wanted to say something.
Yes, Madam. It's just a prayer basically on humanitarian grounds without the prosecution that are issued. My client has been unwell the last few days, I think since Tuesday or Monday. Lady, we're just praying for an order that he be taken for medication.
That one will make. Is usually on some medication, or it's just some illness?
Yes, he is on treatment, I'm informed so. Unfortunately for him, he's only been able to get painkillers since Monday.
You need to indicate whether on the 8th, which is the time the prosecution is requesting to have the matter heard, whether you'll be available 8th of October.
It seems like I had prayed for an earlier time, but
That's the earliest, I can assure you. You are available on the 8th?
I will be available. Even if I wasn't, I would just make myself available.
What does that mean? You can send one of your colleagues. We don't want you to come crawling or something like that.
I really visit somebody who's enjoy some of the rides I do.
Start. Kasper, simama. Stand there.
There's a prison here. Any of the senior people here? Oh, you are here. So you'll be escorting him to see a doctor for medical attention. I've made the order, it will be extracted, but I want you to do that. Okay. So I've said we are adjourning the case at this stage. Consolidation and bail application will be heard on the 8th of October this year. The accused will be remanded at Industrial Area Prison until then.
Criminal case number 14 of 2018, Moses October Jackson. Moses.
In the matter I'm present in the state, I confirmed the issue of the POR reports. The same is ready.
Is the accused here?
Yes, madam. I saw him.
This is for the accused.
Wakili yako?
Yes, I'm going to. Is a probation officer in court?
Madam, there's none in court.
We didn't ask for a pre-bail, we asked for assistance to trace relatives.
Very true. I think
So this one was not called for and is not helping us. Is the relatives of the accused here? Any relative?
they have seen none.
Kivetonga.
Kuna watu wa familia ya Moses Okweba Jackson wako hapa. Kuna mtu wenu umeona hapa? Mbali.
Give it 2 or 3 weeks. And the probation misunderstood the direction of the court. So because of that, he has to come back again. Is it on the 16th of October? You come back again on the 16th? In the meantime, the probation should be asked to help trace the accused relatives. So that they can help us with the mental history of the accused. Now, we'll also summon his lawyer, Mr. Saini, to appear before the court on the 16th.
Must be.
Next is ruling in criminal case number 46 of 2017, Zakaria Obado.
Finally, for the defense, here together with Mr. Sazano. For the prosecution, I appear with my colleague, Mr. Uteti, Mr. Imbali, and Mr. Owiti.
May I please, Your Ladyship? Caroline Kamal, been instructed by FIDA family. In the matter, I appear together with Honorable Kaluma, Ms. Mukali, and Mr. Ayora.
We are
Yes,
present. Yeah.
Mr. Kaluma.
Karuma
You
is
said they are present, so I wanted to see everything.
unfortunate. Karuma is not there.
Okay.
Karuma.
So you are there. Who was the other person?
With Ms. Mukali, present, my lady.
Mr. Ayora.
Can you stand? Now this is the ruling on the bail application, which was dated 24th of September 2018. I will not read the whole of it. I will just read excerpts. But I'll start by saying I've summarized what every party submitted before me in the body of the ruling and considered the authorities that were cited and the law. On the issue of the compelling reasons, now there is no dispute that compelling reasons include a consideration of the nature of the offense, the strength of the evidence, which supports the charge, the gravity of the punishment in the event of conviction, the previous criminal record of the applicant, the probability that the accused may not present or surrender himself for trial, the likelihood of further charges being brought against the accused, the likelihood of the accused interfering with witnesses or misappraising evidence that may incriminate him, the probability of finding the applicant guilty as charged, the detention for the protection of the accused, and the necessity to procure medical or social report pending final disposal of the case. Now, in the recently launched Criminal Procedure Bench Book, at paragraph 105, it has been dedicated to outlining of compelling reasons as stated in various cases, policy guidelines, and others. Now, these are the likelihood of the accused. The likelihood the accused may fail to attend the court, that he may commit or abet the commission of serious offense, endanger the safety of victims, interfere with witnesses or evidence, endanger national security or public safety, and for the protection of the accused person. That list is, however, not exhaustive. Now, on the right to presumption of innocence until proved guilty, this court recognizes the importance of Article 50 of the Constitution, that an accused person should be presumed innocent until proved guilty. The accused person should be released on bail or bond whenever possible. Those are the words found from the bail and bond policy guidelines. Opposition to granting of bail is not a violation of that right. That is why the Constitution uses the words unless there are compelling reasons. That puts a duty on the prosecution to place before the court any evidence they may have on compelling reasons for consideration by the court. It is the prosecution which has the onus and the burden to prove the presence of compelling reasons to deny bail. It is also the reason the victims are given an opportunity to be heard before bail is considered, and a mention made of the requirement for victim impact statement in the Criminal Procedure Code. Indeed, in this application, the victims were represented by counsel, and they did make submissions at the bail hearing to argue then that any opposition to a release of an accused person on bail is a violation of that right is erroneous. On the issue of dignity, this one was raised by Mr. Ombeta and a response by Mr. Ondari. I want to say that I do not wish to define the word dignity. However, I think it has nothing to do with what Mr. Ombeta urged or what Mr. Ondari thought it could mean. Dignity has to do with the treatment of an accused, not his status. The binding constitutional principle of right to equal treatment before the law abides here. There cannot be equal treatment before the law based on the status or lack of it of an accused person. I look at dignity in terms that are set out under the International Convention of Civic and Political Rights that was quoted by none other than Mr. Ombija, the lead counsel for the accused. That instrument provides that an accused person shall, save in exceptional circumstances, be segregated from convicted persons and shall be subject to a separate treatment appropriate to their status as unconvicted persons. Having stated that, I just wish to state that the segregation referred to here does not mean that it can only be realized by the release of the accused from the remand. It means the physical segregation within the place of detention, and so far no complaint has been raised in that regard. And I have said that if it is raised, it can be dealt with at any stage during the proceedings. Now, on the issue of complexity and the strength of the prosecution case, I have noted that the prosecution is here to provide witness statements, documentary and other evidence they intend to rely on at the trial. Now, failure to provide them cannot be interpreted to mean that the prosecution has no case at all, unless good grounds exist which could lead to such a conclusion. On the issue of capital charge and the issue of right to bail, now on this issue, the seriousness of a charge and severity of the sentence to to be meted out is a major consideration on the issues of bail. It is, however, considered alongside other factors and cannot, standing on its own, be a ground to deny bail. On the investigations still being underway, I've said investigations are still underway, cannot be wished away, and it is evident, given the fact that other persons have subsequently been brought before this court facing the same charge. On the issue of the status of the accused person and likelihood to influence the case, I've said that when a person is elected as a leader or representative, he or she commands a lot of power, both within the confines of the particular area they represent and also even outside of it. There are measures the court can apply to ensure such power does not affect the case, for instance, by imposing strict terms. Now, the likelihood of interference with investigations, witnesses, threats, and intimidations. The nature of the case has been changing, and more additional persons are being brought, charged before the court with the same offense. Interference with the case is not just constructive. By meddling with witnesses or with the case, it can also be affected indirectly, say by the releasing of some of the persons facing the same charge while others are being arrested. Now, on the issue of confessions, I've said the issue of confession is a matter for trial, and that is not, and it is not before this court. And then the issue of the safety of the co-accused, which was also raised, is not a matter before the court, and the court cannot decide at this stage, as there are no co-accused in the information which is before the court in this case. On public interest, order, and security, I'll say that the issue of public safety and security is a matter that the parties in this case cannot comment on for lack of material to form a basis for an argument either way. Now, the only material before the court is the affidavit by Inspector Mwangi. It contains averments that security may be destabilized. The court is, however, aware of threat to security in the area the offense took place, and that is what informed the arraignment of the accused person here in Nairobi. So security is an issue. However, at this stage, I find it difficult to draw a conclusive finding at this stage. Now, the conclusion is that the application cannot be determined before the witness statements and other evidence are availed to all the parties. That is the only way that this court can fully exercise its discretion, applying the factors for consideration in determining whether or not any compelling reason exists to deny bail. So at this stage, I'm disallowing the application. Now, can you come back on the 8th with the other two matters? Can we put it for the 8th, like the others, for consolidation purposes?
We'll come on 8th.
I've said at that time, after the consolidation, the statements will have been supplied. The accused in this case may consider to reapply for bail. So you'll be remanded until that date. Do you have anything else?
That's all.
Court is adjourned.
Gori Governor Zachary Okoth Obado, a dejected man after High Court Judge Justice Jesse Lesit denied him bail, and he'll still be in police custody at the industrial area remand, where he'll be spending another 8 more days before the next hearing. And the justice there has announced that she has offered the legal team to reapply for another bail in terms of getting the governor to be released from custody, even as investigations continue. Well, very, very interesting development into this case. So far, the governor for Migori County has been in custody since last week on Friday. This is, of course, as you can see there, he's being escorted back into the holding area. Thereafter, he shall be, of course, still being held in custody. The legal team is very much consulting, trying to just ponder on what next. And we have our reporter, Francis Ontomwa, standing by at the Milimani Law Courts. Ontomwa, what does this mean for the case?